Mr. Nelson.
Good morning. If it please the court, Macy Nelson for the appellants in this land use case arising out of Prince George's County. This case concerns whether unique language in the Prince George's County subdivision.
I have a concern before you go to your concerns.
Yes, sir.
The third question presented in your brief is an alternate ground for your argument, but it's not mentioned in your petition for certiorari. This court only granted certiorari on your first two questions, and you've added a third question which wasn't known to this court at the time you filed your petition for cert.
Your
We've
Honor,
been putting footnotes in our opinions lately, hoping people would read them, saying that if you don't put it in your cert petition, you're not supposed to put it in the brief, and generally we're not going to consider it if it's not in the cert petition.
we viewed it as a corollary to issue.
Alternate, if not the same as
I'm
corollary.
sorry to hear the question.
You presented in your brief alternatively if Archer's Glen. If it's an alternative ground, it's an alternative ground. It's not somehow melded to the other two grounds.
Your Honor is correct that we view the central question as a law of the case issue. I was trying to give guidance to the court that the underlying decision was correct, to try to satisfy the court that if the court did rely on the law of the case, it would not be making a legal error, because one of the defenses to the law of the case is if there was a manifest error in the case, the opinion on which the doctrine is referring to. So we viewed it as appropriate, but understand Your Honor's point, but the thrust of our argument is the law of the case. We think that decision was right. We also think that the doctrine requires that the Second Court of Special Appeals rely on the First Court of Special Appeals.
Doesn't your law of the case argument hinge on the so-called guidance, legal rulings under Rule 8131A?
Well, this, yes and no.
As I read your brief, it does.
This case is interesting because traditionally in the law of the case argument, you're referring to a holding of an earlier case. We don't have a holding here.
Well, no, my question gets more basic than that.
Yes, sir.
I don't think Rule 8131A has any application whatsoever when an administrative agency is involved. If you read the rule, it deals strictly with the relationship between the appellate courts and trial courts.
Yes, sir.
Not administrative agencies.
Well, it is a rule of procedure for the court system, so it would govern, I respectfully suggest, the circuit court's decision on remand, Judge Nicholas's
Well,
decision.
I'm not at all sure if this is probably one of those situations where both the circuit court and the appellate courts have the same standard of review vis-a-vis the agency.
I'm not sure if that was a question or a statement.
Well, I'm wondering why that isn't true. You're not talking about the appeal Court of Special Appeals wasn't based on a circuit court error. It's based on an administrative error, correct?
That's correct. But our view is that
And the rule you're relying on only applies to the relationship between an appellate court and a trial court. And where you're talking about an issue before the agency, circuit court and both appellate courts all sit in the same posture.
well, maybe I can address it this way, if I may. We believe in the First Court of Special Appeals opinion, the court offered guidance because their phrase was, additionally, our opinion addresses two issues that may rise again upon remand. In an attempt to avoid the expense and delay of additional appeals, we offer the following guidance. And then the court went through and analyzed the unique language of the Prince George's County subdivision regulations, and based on its analysis of that unique language, unique to Prince George's County, we're not talking statewide, we're talking Prince George's County. Based on that, the first court said it would make little sense if compliance with the general plan were not a prerequisite for subdivision in Prince George's County. We assert respectfully that that rule governed the planning board's analysis on remand.
Why? You hung your hat in your brief on Rule 8131A.
I respectfully...
And what I suggest to you is that guidance that rule talks about is 100% from an appellate court to a circuit court or a district court.
I don't mean to interrupt the court, but I would respectfully disagree with the court's interpretation of a brief. We don't hang our hat only on Maryland Rule 8131. We observe for this court's benefit that the court
But for that rule, it's just dicta, so-called guidance.
Well, it is dicta.
How can dicta be law of the case?
Well, this is why I think this case is interesting. And I think this is why this court, I assume, granted certiorari. Because if it were a holding, we wouldn't be here. But what do you do when you have a case such as we have here, where a court of special appeals opinion looks at a case that's fully briefed and says, we're going to revert, our holding is the agency failed to articulate its findings, we need to vacate and remand. That was the holding. But because the court recognized that there would be some issues that will arise again on remand, and in an attempt to avoid the expense and delay of additional appeals, we offer the following guidance for the parties, and then it's cited.
How can the term guidance ever be elevated to a law of the case? Courts know, this court and that court know very well how to direct lower entities to do things. We occasionally remand, reverse, send back to this court with directions to do this.
Yes, sir.
And direction is a little bit more than guidance.
Yes, sir. That's what makes this case, I think, interesting. And my point is, well, then why would the court go through that analysis? Why would it do that? And then I say to myself, what would happen if on remand the agency or the circuit court ignored that guidance? I suspect that if the circuit court ignored that guidance, the circuit court...
Was that guidance an issue the first time around before the agency?
Well, understand that, I don't mean to say that, the answer is yes and no, but the court said we
Well, which is it?
I'm sorry?
Which is it? You say yes and no.
It's
I want to know
both.
which it...
The court vacated because of the agency...
In other words, if the Court of Special Appeals, by guidance or any way you want to do it, starts giving directions to the agency on issues that were not litigated by the agency, you also run into the problem of judicial review is limited to those issues decided by the agency.
But the reason I said yes and no, there was a general question about whether or not the master plan and the general plan were both binding documents, whether the agency, whether the applicant had to comply with the requirements of both. And what the agency and what the court said was, we find that the parties agree that the master plan, the area master plan, was a binding document. There was a question about the general plan. So
I have been tempted, I just want you to know,
Yes,
and have not done so, to get into a discourse with you, is why you've got a master plan and a general plan in this particular jurisdiction. I'm sure it's none of your doing, but generally speaking, general plans are master plans, and master plans are general plans. But I don't know what you've got down there. And subdivision plans are subdivision plans. One of them is binding and one of them is not binding. And so I have been a little confused. Not your fault. I'm sure my partner, Judge Harrell, will straighten that out, hopefully.
Well, may I just take a shot at it very briefly?
Okay.
In Prince George's County, there is a general plan that is countywide. And then they break the county into what I think of as regions or subregions. And they have area master plans for part of the county. So you have the general plan, which speaks generally and talks about a developing tier, a developed tier, and a rural tier.
So the general plan is superior, above
Yes, sir.
the master plan, so
Yes,
the
sir.
terminology is what's confusing me.
Yes, sir.
Master says, I'm master
I
over
know.
everything. This way, it's,
Master plan is really a portion of the county. We're in the sub-region 6. It's in the rural tier, which I think of as really as the old tobacco land. It's a beautiful rural land on the east side of 301 in the south. And the reason why there's this legal debate about what's binding, what's not, is if you look at the subdivision regulations, the Prince George's County subdivision regulations, it says expressly that development, I paraphrase now, we quote it precisely in the papers, the subdivision plan must conform to the area master plan. The language is not quite as precise with respect to whether or not a general plan is also binding. This is the third issue that you talked about, but the Court of Special Appeals went through the first Court of Special Appeals went through that analysis in what I call the Archer's Glen 1 and said it would make little sense if compliance with the general plan were not also a prerequisite for a development.
But they also said we find it unnecessary and inappropriate to definitively resolve how the general plan should apply under the subdivision. I mean, they were very clear about that.
Well, I must say that one could look at different parts of that opinion and draw out different quotations. That is a quotation that is helpful for my adversary, and I would direct Your Honor's attention to the sentence that says it would make little sense if it were not a prerequisite.
But it also says, pursuant to our remand, the parties will have an opportunity to revisit this issue in light of the above comments. So,
and the above comments were, and it went through the unique language that Prince George's County would make little sense if it were not a prerequisite. And then we went back, and there was another hearing, and Judge Nichols, in reviewing that record, followed the guidance of the Court of Special Appeals precisely. I respect his analysis. If one reads the Circuit Court's opinion, almost tracks verbatim the Court of Special Appeals opinion. And he said that the board, he accepted our argument that the board failed to articulate its finding with respect to the 1% rule, which appears at page 176 in the extract. And then when that was appealed, of course, the second Court of Special Appeals relied, Your Honor, on the sentence you just quoted. Our view, and I understand that I'm not pointing to a holding. We wouldn't be here if there was a holding I could point to, but what I'm saying is that if you're a citizen embarked in a judicial process and you go all the way to the Court of Special Appeals and the court says we're going to offer this guidance to guide further conduct in this case, and then you rely on that at tremendous sacrifice and go to the agency, appeal the Circuit Court, and then the Circuit Court follows the guidance of the Court of Special Appeals, and then you get reversed, I don't think that's the way it ought to work. It's not fair to citizens who are participating at great expense in the judicial process. What's the point if the issue's always in play? We can never get a resolution. So for those reasons, we urge this court, it's only for the sake of fairness, that if a court issues guidance to reduce the expense and avoid future appeals, not to make my clients relitigate the question. So for those reasons, we respectfully urge this court to hold that the doctrine of the law of the case applies in the circumstances of this case where a court offers guidance to reduce the risk of future appeals. There is a second procedural point which is really also very interesting, I think, and that is the question of whether the planning board has standing to participate as an appellant in this case. And
I thought the argument was they had no right to bring an action in the Circuit Court.
Our argument is based on the APA, and if you look at the APA, it's...
No, you don't understand my question.
I beg your pardon.
I thought you were saying not just that they couldn't be a party on appeal, rather they had no right to bring an action in the Circuit Court.
Oh, that's correct. Perhaps
that is your argument.
Yes, sir.
And you did not, in the Circuit Court, raise the question of whether they were an aggrieved party.
That is also correct.
Okay. we have a whole line of cases that says that type of standing issue, whether you're an aggrieved party in an administrative review case, is waived if not raised in the circuit court. Two Sugarloaf cases said it. Medical waste case said it. I can give you some more.
Actually, medical waste didn't say that.
Well, medical waste ultimately found no standing on the part of some, but
On the part
in the discussion of standing. Earlier opinion of Judge Diggs said it.
Now, I would argue that medical waste was a different point, but my point is this.
Well, how you argue with the Sugarloaf, or I think it's the Howard Research and Development.
Our argument is this. Under the APA, the planning board did not have the right to participate as a responder and appellee in the circuit court. I did not raise the issue in the circuit court. Next time, I will.
Good.
I raised it in the Court of Special Appeals, and I believe the central question was waiver. My adversary did not raise waiver. The Court of Special Appeals addressed the question. Now we have a published opinion from the Court of Special Appeals. I respectfully suggest it's erroneous, holding that the planning board has the right to take an appeal from the circuit court to the Court of Special Appeals. We say that analysis is flawed. It's flawed because the planning board did not have the right to appeal from the circuit court, and if it didn't belong...
You mean file an action for judicial review?
I beg your pardon?
It did not have a right to file an action for judicial
under
review.
The APA, and the Court of Special Appeals relied on the second level of the judicial review, where if you're in the part of the circuit court, you can appeal to the Court of Special Appeals. I say the question is, did I waive that point? And I say, respectfully, no, sir, I did not. Next time...
Well, all the cases say you have.
Well, I'm not aware of any case where a court...
Howard Research and Development, Judge Diggs held, if you fail to raise, in a judicial review of administrative agency, fail to raise the question of standing because the party's not aggrieved, it's waived, and the party is given standing. It was also held in the Sugarloaf case, and it's been said many times by this court.
Well, I would respond this way. Number one, our argument was addressed by the Court of Special Appeals. Number two...
Well, I don't know that that saves anything.
I think it should. For those reasons, I'm near the end of my opening time. For those reasons, if it please the court, I urge the court to hold that the law of the case doctrine applies to the circumstance of this case where a Court of Special Appeals analyzes the issue in the fashion it did, where it offers guidance in the fashion it did, and where the parties and the lower court relied on that guidance. We think that's the just ruling in this case. With all due respect to Judge Eldridge's questions, I urge the court to address the standing of the planning board. I don't think that my clients waived that issue. I think it's a very important issue. The Court of Special Appeals addressed that question. And it's also central to my thesis in this case, which is I'm trying to make the judicial system accessible to people who need representation, and I'm trying to streamline it as much as I can in compliance with the law. So for all those reasons, I urge the court to reverse the Court of Special Appeals. Thank you so much for allowing my clients to present this case to this court.
Thank you, sir. Ms. Bramble?
Good morning, may it please
Ms.
the
Bramble,
court.
you cite, I think it's in your brief on page 27, you cite Trail versus Turnip and Run.
Yes,
You would agree, would you not, that the majority opinion in that case and the dissent both leave plenty of room for this court to find, as it has repeatedly found, that subdivision regulations are binding?
Subdivision regulations are binding. Well, of course, the subdivision regulations are, and then in terms of this case, the word conformance was discussed at great length by this court, and I think in this instance, the subdivision regulations, specifically 24-121A5, make the master plan binding.
Yeah, the subdivision regulations themselves make the area plan binding, is what you're saying.
Correct. That's my understanding of it.
I just thought I'd start at the end of your brief instead of the beginning.
Okay. And again, my name is Megan Bramble, and I'm here on behalf of the property owner applicant in the underlying subdivision approval. The first issue discussed this morning was with regard to the law of the case and whether the Garner court, which is how I refer to the Court of Special Appeals' first opinion in this case, whether the Garner court decided the issue of the weight to be afforded the 2002 general plan and subdivision regulations. It is our belief that the law of the case does not apply, consistent with the discussions that the court had with the appellant just now. With regard to the weight given to the general plan, the Garner court specifically stated the parties dispute whether the planning board is required to conform to both the general plan and the master plan, or simply just the master plan. And then the Garner court went on to state resolving that issue is unnecessary to our holding. The Garner court instead offered guidance to the planning board on remand, which the planning board followed, when it stated that the general plan should play some role in subdivisions in Prince George's County. The question here is whether the Garner court made a decision when it offered that guidance regarding the weight to be afforded the general plan of Prince George's County. The answer is no, and this is not the law of the case. The reason the Garner court did not decide that issue was just as the Court of Special Appeals stated yesterday in Maryland National Capital Park and Planning versus Anderson. Courts are reluctant to take action against administrative agencies until the controversy is ripe for review, or in other words, until the agency decision is formalized and its impact felt by the parties. Garner did not want to take away the administrative function of the planning board in supplementing the record with findings to support its conclusions. This was the same reason that this court determined in Rear versus the State Department of Assessment and Taxations that the law of the case doctrine was inapplicable, because the Court of Special Appeals in the first case in Rear versus SDAT didn't have enough facts on the record to, they use the word definitively conclude, for the court to reach a definitive conclusion. The same is here in Garner. The Garner court did not reach a definitive conclusion on whether the general plan or the weight to be afforded the general plan and subdivision regulations, simply because there wasn't enough facts in the record. The planning board didn't litigate the issue, so the court sent it back down to the planning board to do that.
Counsel, wouldn't you agree at the very least that this case serves as a cautionary tale to appellate courts to be circumspect in their generosity in sharing its views with the litigants on matters that it need not reach?
I would say yes. However, I think the guidance was helpful at the planning board hearing. It was helpful in guiding the planning board. There was a very lengthy discussion on both compliance with the master plan and general plan that makes the record here abundantly sufficient for the approval.
You didn't file any cross petition, did you?
No, sir.
Well, if in fact we don't address question number 3 because it wasn't presented in the cert petition, and if we find that the issue of standing wasn't presented at the circuit court and it should have been, and therefore it's waived, and if we find, as we might, that the law of the case doesn't apply when the circuit court does anything, what's left for us to do in this case?
Affirm Archers. I think Archers, the Court of Special Appeals and Archers said it right on when they concluded that the master plan is binding and it was partially expressly amended.
Do you think we should be reaching that?
No, sir. I think that the cert petition only addressed 1 and 2. But I would hope that the court would affirm Archers because that also addresses another issue that affects a couple other cases in Prince George's County right now.
Why should we get involved in?
Here we go.
It's not properly before us.
then no, there are no other issues left for this court to address.
And just standing in law of the case are the only two things before us under the cert petition.
I agree.
Okay.
With that, in the discussions on the standing and law of the case, I would ask this court to affirm Archer's, and thank you for your time.
Thank you, ma'am. Ms. Green?
Good morning. May it please the court, my name is Andre Green and I represent the Planning Board, Prince George's County. Really don't have much to say at this point, except that I think the first issue dealing with the law of the case is a very simple issue. There was no decision on whether general plan conformance is required, and therefore there was no guidance or requirement for the planning board. I agree with Judge Eldridge when he said that law of the case doctrine does not apply to an administrative agency. The administrative agency has to use its discretion, and it has to weigh the factors and the facts presented before them, and the court's role is to review that discretion and review that weighing of the facts.
You think that an administrative judge, an administrative hearing body who receives an opinion from the Court of Special Appeals which says you ought to consider this, that, and the other, will disregard it or should?
Oh, no, absolutely not. I think they should pay attention to whatever direction the court gives them. But I think in using that direction, they have the requirement, the responsibility to weigh the facts against that direction. Not ignore the direction, but take that direction and weigh the facts and make the findings of facts required under the specific case. But in our case, I don't think that was even an issue, because the issue of whether or not the general plan was binding was not even decided. So there was nothing for the planning board to follow. The court simply said, we think that you should look at this. And that's exactly what the board did.
It said two things. One case, it seemed to suggest that on the one case that that it has to have some impact. Mm-hmm. And on the other hand, it says we don't have to decide it.
Well, I think it said it should have some impact, but we're going to leave that to you to decide.
How much impact? We're going to leave
Well, that's
you.
what they didn't decide. That's
what they said. Well,
yeah.
How much? It seems to me that at least they were saying that you ought to give it some weight.
I agree. I agree that
To the extent they gave it some weight.
It was for the board to decide
how much
weight that would be.
So you're suggesting that what happened when it went back, it having given it some weight, the court merely said that it either gave it the right amount or it didn't give it enough.
Right. That is what I'm saying, and that is what the court noted, that it is the board's jurisdictional issue to decide whether and how much weight to be giving to the issues presented before it. The general plan is a very broad document, and it covers the entire county. It in no way, shape, or form could address each individual little property. That's where the master plans come in. They address a certain area. And the term master is used to say this is the plan for this entire area. An individual subdivision plan deals with a particular parcel. But the general plan itself, in the general plan,
The general's the master, it's the real master. It's the master over the master.
It's for the entire county.
Okay.
Whereas the master plan only governs a certain geographical region.
If there's a conflict between the general countywide plan and an area plan, which control it?
It depends on which one came last. And in this case, the general plan.
So you can actually, in effect, amend the general countywide plan by subsequent legislation creating an area master plan. It operates in effect as an amendment to the, I'm not saying you can't do it, but I'm saying
If that is what the governing body decides when it enacts the master plan. As in the general plan, it specifically said in the resolution that adopted the general plan, it says it supersedes or amends the area master plans where in conflict. You can do that through a master plan under the law. But the district council would have to so state that, we recognize this conflict between the area master plan and the general plan, and the area master plan is intended to amend or supersede where in conflict. But this particular general plan and general plans by nature are general, and they offer guidance. I mean, the plan says itself in numerous places that if we recognize that it's general in nature, that it's to provide broad strategies to guide the future growth and development in the county. It's an objective. It only is an implementation. That further refinement has to be done through the area master plans, the county regulations, and included in those county regulations, they're not only talking about subdivision laws. They're talking about transportation issues. They're talking about water and sewer
Thought you
plans.
had separate master plans for water, separate, I list them in one of these footnotes here. There's 7 or 8 things, other kind of master plans you have for specific things.
Yes, that is correct. And the general plan envisions the use of all of those different regulations in meeting its goals and objectives. The general plan is not directed to subdivision and subdivision only. These general plans and these objectives and these missions are directed to the subdivision plan. It's to the county as a whole, and it so states in the general plan, in its implementation section. It specifically says that through further refinement and new regulations that these goals will be achieved. As to the standing issue, I think your most recent decision in Howland is applicable. Just as in that case, the planning board here is more than just a quasi-judicial agency. It sets policy and enforces policy. It starts the whole process. The planning board approves the master plans and the general plans and creates the documents that set the policies that the district council then adopts. And so I think that the Howland case is on point.
You want us to decide that issue?
No, I personally would not like you to decide anything other than to deny a petition for cert, but I felt that I had to address these issues because they were before you here today. And I have nothing else if you have any questions.
Thank you, ma'am. Mr. Nelson.
With the court's permission, I'd like to follow up with Judge Bell's question, which was was addressing the question, well, did the First Court of Special Appeals give some guidance, and what did it mean? And I'd like to address that issue, if I might. We say that it did, of course, and we direct the court's attention to extract 176, which says that 1%, less than 1% of all residential development countywide can occur in the rural tier. At a minimum, the planning board on remand had to address that question. Judge Nichols did. The planning board is silent with respect to the compliance with the 1% rule. On appeal, the planning board offers new evidence for the first time at Appendix 64, where the planning board submits a document that says that almost 4% of all the residential development that's applied for or approved is in the rural tier. And at a minimum, this is the type of information we respectfully suggest must have been analyzed by the planning board in order to conform with the First Court of Special Appeals opinion. It didn't follow that guidance, and Judge Nichols, we respectfully suggest, correctly vacated the decision and remanded it back to the planning board to elucidate those factual issues. So we urge the court to adopt the analysis of the Judge Nichols in the Circuit Court. With respect to the appellate issue, the standing issue, my colleague cites Howland Realty. I'll just note for the record that's a non-APA case. We're in the APA context. There are different rules governing the standing of the agencies. In this case, the agency was not a party below, and therefore we assert respectfully, Judge Eldred, that it didn't have the right to participate in this case on appeal. So for all those reasons, we urge the court to reverse the decision of the Court of Special Appeals. Thank you so much for your time.
Thank you all.